poverty of certain countries and oceans again play a very significant role in reducing the poverty around the world. But unfortunately, not all countries have equal access to oceans. Although they are still, in our time, increasing importance in world economy, and especially fighting against poverty, but unfortunately, there are many countries which do not have direct access to oceans. That's why this has been always a very significant issue. When we talk about the maritime law, we should consider the situation of landlocked states or geographically disadvantaged states because they have very limited access or no access to oceans. It was first time in international maritime law that the situation of the case of landlocked states have been discussed, which was in Geneva Law of the Sea Convention. There is a, let's say, a starting article for the first time in maritime law talking about landlocked states. It was Article 3 of the Convention on High Seas, and it says that landlocked states have right to access or right to transit to oceans. So the states which are transit states, that means the states which are in the middle of these countries and the oceans, should provide access to these such landlocked countries. The second step was an international convention in 1965. A special convention has been signed and put into practice in order to protect the right to access to oceans of landlocked states. But all of them were quite limited and ineffective in legal terms. So that's why when all the states started to discuss about the Law of the Sea Convention in the 1970s, there were a group of 50 countries during that discussions. These 50 countries were called landlocked and geographically disadvantaged states. These 50 states, although there were many differences between themselves according to their location and economic level of development, but they managed to establish a group and they acted together to put the necessarily effective provisions in the 1982 Law of the Sea Convention. For about 10 years, this group of countries worked together. And eventually, they managed to put enough number of provisions in the 1982 Law of the Sea Convention. Let me carry on defining, according to the Law of the Sea Convention, what landlocked state means and what geographically disadvantaged states means. If we start with the landlocked states, the Convention in Article 124 defines them as the countries which have no direct access to the oceans. There are many examples. We know some of them, like Uzbekistan, Kazakhstan, or in Europe, Serbia, for example, or Switzerland. All these countries have no physical direct access to oceans. Does it mean that since they have no direct access to sea, so should they be excluded altogether from the benefits of the oceans? So, because the answer is no, then 1982 Law of the Sea Convention gives certain rights to these countries. So that's the definition. They have no access, physical access. The Convention, for the first time, created another concept, which is called the geographically disadvantaged states. These states are not landlocked states because they have access to oceans, but still they are regarded as geographically disadvantaged states. because they have a very limited physical access to the oceans. Or sometimes such countries have access to seas, but the seas are very narrow, like imagine the states bordering the Caspian Sea. Although they are bordering a sea, but still the sea is very limited compared to the oceans, then they still can be regarded as geographically disadvantaged states. Since we have very limited time, so I would like to talk about the rights of these countries briefly, then look at the existing situation in the world. We are now certain that there is a legal right for these states. This right is a right to access the sea through transit states. Even if they are landlocked, still they have a legal right to reach to the sea over the countries which are located between these countries and the oceans. That's like a right to pass over these countries to the sea, to get the benefits of especially the high seas. You know, that concerns the living natural resources and some other benefits of the oceans, especially the high seas. So the transit states should provide the necessary facilities and necessary permission to these countries to reach to the oceans. That's the legal obligation on these countries. There are many other rights, like, you know, they have a right to use the ports of these countries, especially if they are in the same region of the world. They have a right to use their rights, and the transit states should provide their ports to be used by these landlocked countries. And many other rights, but we have very limited time, and there would be another presentation about their rights, so I should stop here and look at the case of geographically disadvantaged states. These states have some rights to get the benefits of exclusive economic zones of coastal states, if they are in the same region. Imagine we are in the Mediterranean Sea, and there are many countries bordering the Mediterranean Sea. Some of the countries have very limited access to the oceans, and some have enormous amount of exclusive economic zone compared to the others. Then these countries should provide, you know, some benefits, some facilities to these disadvantaged states to get the benefits from the exclusive economic zone of the same region. So they should establish different modalities of cooperation to provide, especially from the living natural resources, fisheries, to the disadvantaged states. There are many others. The convention talk about the states of, states are geographically disadvantaged. But if you look at the real situation now, unfortunately, although there are many provisions in international law, especially in the law of the Sea Convention, some of them are not really properly applied. We have seen some examples in Africa, very successful examples in African countries. You know, they have established a group of countries. You know, they are collaborating with each other to reach the sea and get the benefits from the seas. But unfortunately, there are many other examples that, you know, they have no effective access to the seas, and they have no effective system of getting the benefits from the oceans. This is a significant issue because oceans play a very significant role in reducing the poverty. If we look at the states which are landlocked or geographically disadvantaged, some of them are really the least developed countries in the world. You know, there are 44 landlocked states, and over 50 countries are geographically disadvantaged countries. So some of them are really poor countries. We call them least developed countries. There are at least 12 least developed countries among these 50 countries, so they have no effective access to oceans. So that's why this is a significant issue, and we should talk about how to realize these provisions which exist in maritime law in our time. So I should stop here. I think we have very little time. Maybe continue if there are not many questions.
Thank you very much, Mr. Leader. You used your time. Thank you very much again. Second speaker will be Professor Dr. Hamburg. He invited from Deniz Hukukundaki Doctor in Law from the University of Vienna.
Thank you very much. First of all, let me express my sincere gratitude for having been invited to this highly interesting international conference. It is also a high privilege to be able to address such an audience of distinguished experts in maritime law of the North Sea. As time is very short, I will just highlight some of the points of my presentation which I prepared in writing and which will be published later. As you know, the United Nations Convention on the Law of the Sea has rightly been called the Constitution for the Oceans, and its 40th anniversary has been commemorated by a number of events in the course of this year. Because let us not forget, it seems quite doubtful whether an undertaking of such magnitude would be successful today. And while the riches of the oceans and the seas were originally thought to consist of living resources only, in the course of the 19th century, this space also began gradually to be seen as an important depository of mineral resources. And seabed mining was already proposed as early as 1876. And only in the 1960s, there was a sudden surge of interest in the exploitation of the deep seabed, and it was thought there would be a fortune on the seabed which should benefit humankind as a whole, and not be left to technologically advanced countries alone. And the spark for this common heritage and maritime concept was provided by Avrasya of Malta on November 1st, 1976. And from his speech at the UN General Assembly, a straight line can be traced to the Third United Nations Conference on the Law of the Sea and the Convention. And this Maltese proposal was welcomed by the landlocked countries from the very start, because they were believing that, at least to some degree, the effects of the unfavorable geographical location with respect to maritime areas could be mitigated. So what is a landlocked state? The Convention defines landlocked states as a country and states which have no seacoast. And the use of the term seacoast indicates that countries bordering a body of water that is itself landlocked, even if called a sea, are to be considered landlocked and not coastal states. It is to be noted that out of 43 landlocked states with UN membership, 32 are developing countries. And of these 43 landlocked states with UN membership, only 28 have become parties to the Law of the Sea Convention, of which 20 are landlocked developing states, 9 of which are also least developed. So this means around 1/3 of the landlocked states still remain outside the Convention, which seems all the more regrettable when considering the great efforts at the conference to safeguard the rights and interests in the maritime domain. But it should also not be overlooked that the Convention was adopted as a package deal and could, by its very nature, not wholly satisfy the aspirations of all the segments of the international community. A pillar of the current maritime rights of landlocked states regarding the common heritage of mankind is enshrined in Part 11 of Annex 3 of the Convention, and the core provision is Article 136, declaring the area, the international seabed area, which is defined as the seabed and ocean floor and subsoil thereof, beyond the limits of national jurisdiction and its resources, the common heritage of mankind. Why? In order to preserve the greater part of ocean space as a commons open to use by the entire international community. And furthermore, no claim or exercise of sovereignty or sovereign rights over any part of the area or its resources, nor appropriation by any state national or juridical person is to be recognized. So the prohibition of occupation and appropriation has thus been given a legal status similar to that of used coins, and that provision may also be considered as an obligation of all states, not only of states parties to the Convention, and thus establishing an objective legal regime. All rights and the resources of the area are vested in humankind, on whose behalf the International Civil Authority, ISA, is to act as the kind of trustees, and all states parties to the Convention are ipso facto members of the International Civil Authority. The Convention lays down basic policies relating to activities in the area. I will not go into detail here, but one of the important tasks of the International Civil Authority is also the effective protection of the marine environment from harmful effects which may arise from activities in the area and the conservation of the natural resources of the area. The Convention contains a number of provisions specifically aimed at promoting the interests of landlocked countries. It deals with the effective participation of developing states in activities in the area, with due regard, in particular, to the special need of the landlocked and geographically disadvantaged among them, to overcome obstacles arising from their disadvantaged location. And there's also a provision which excludes particular consideration for developing landlocked and geographically disadvantaged states from the non-discrimination rule to be applied by the civil authority in the exercise of its powers and functions. Within the civil authority, the landlocked states are also accorded some special rights. So, for instance, developing landlocked and geographically disadvantaged states are to have representation on the Council, which is the executive organ of the civil authority. And it is also provided that when electing 6 members to the Council from developing states parties representing special interests, these interests must include, inter alia, states which are landlocked or geographically disadvantaged. And electing the members of the Council, the Assembly of the Civil Authority must ensure that landlocked and geographically disadvantaged states are represented to a degree which is reasonably proportionate to their representation in the Assembly. But in practice, these provisions do not seem to have had any particular effect on the composition of the organs of the civil authority as far as landlocked states are concerned. It is to be noted that even though these states make up more than 15% of the membership of the civil authority, their participation in its annual sessions has been minimal over the years. And a certain number of landlocked states, particularly developing ones, have so far not participated at all in the work of this organization. And as regards the composition of the organs of the civil authority, it can be seen that the landlocked countries are clearly underrepresented. Only 2 landlocked states, the Czech Republic and Slovakia, which form part of a consortium of several states, are currently involved in exploration activities in the international civil area. And no landlocked developing country has made use of the possibility to become a sponsor of exploitation activities in the so-called reserved areas contributed by a developed state, as several small island developing states have already done. So, although the civil authority is currently moving to the exploitation phase, it is nevertheless uncertain when exploitation and the sharing of benefits will actually start. And it may also be assumed that the proceeds from deep seabed mining will in all probability, at least during the first years, be rather modest. So it would not make sense to make a direct distribution of small sums of money to a large number of states parties. And discussions are currently underway within the ISA as to whether, at least for an initial period, a seabed sustainability fund would be a better option. And such a fund could be used to support global public goods, investment in human and physical capital, or deep sea research and conservation. It would, however, be misleading to consider monetary benefits as the only ones that landlocked countries, especially the developing ones, can derive from the common heritage of humankind and the conduct of activities in the area. And the ICOG has adopted a number of programs in favor of these countries. Let me also mention that altogether, almost 1,000 individuals, including approximately 300 women, have benefited from capacity building programs and initiatives implemented through the civil authority. Let me also, towards the end of my brief presentation, refer to Article 82 of the Convention, which provides that coastal states have to make contributions for the exploitation of the continental shelf beyond 200 nautical miles, up to 7% after 12 years. So, what is the difference between proceeds, monies derived from the activities in the civil area and benefits and payments made under Article 82? When the proceeds from activities in the area belong to the International Civil Authority, its role in the context of Article 82 is fundamentally different. It is limited to the various aspects of revenue sharing. It only can serve as a conduit for the transmission of payments as a trustee of the beneficiaries referred to in these provisions. So it may be expected that landlocked developing countries, particularly the least developed ones, will be very high up on the list of beneficiaries once the civil authority will be able to distribute financial and other economic benefits derived from deep-sea mining, as well as from the exploitation of the continental shelf beyond 200 nautical miles. These rights, however, can only be realized through ratification or accession to the Convention and the 1994 Implementation Agreement. So that's why the civil authority is making every effort to convince landlocked developing countries of the benefits of becoming a party to the Convention. As far as developed landlocked states are concerned, their situation is fundamentally different since the time of the adoption of the Convention. For those that have become members of the European Union or linked to the European Union by specific agreements, these countries can now be considered landlocked in theory rather than in practice. The developing landlocked states, however, find themselves in another situation, in particular as many of them continue to face severe challenges to growth and development due to their unfavorable geographic location. Let me conclude with a quotation from the Secretary General of the Civil Authority, who underlined that the interests of all humanity in the ocean and the conservation and sustainable use of its resources make it imperative that the global governance regime reflects the interests of all states, whether coastal or landlocked. Thank you very much for your kind attention.
Thank you very much, Alan. Professor Dr. Karadağ'ın Budva, he will use a slide deck. Sıradaki Professor of Maritime Law at the University of Ankara.
distinguished delegates, honorable ministers, and other delegates. It's a pleasure for me to be here to give a speech on the rights of landlocked countries over living resources of the sea. Let me just start by making things a little bit lighter so that we relax a bit. I was very curious when I came here because this country is called Montenegro. And I have been wondering whether it means the country of black people or the country of black mountains. Now, I haven't had an answer, but it doesn't matter. If it is a country of black people, then I'm at home. If it is a country of black mountains, I'm equally at home. I will live in those mountains. Okay, as you all know, I'm a professor of international maritime policy at the University of Ankara. I was born in Uganda, although I live in Britain. But I also regard Turkey as my home, and hence the Ugandan flag and the Turkish flag. Right, now, I'm supposed to speak about, I'm the only one talking about the living resources of the sea. Everybody else has talked about other resources. Now, let me just start. Can you see now? Can you all see behind the chairman? Look, these are the countries we are talking about. Let me just give you. The picture is not very good, but these are the countries we are talking about. There are about 44 of these countries. Okay? 16 are in Africa, 16 are in Europe, and I think about 13 are in Asia Pacific, and there are only 2 of them in Latin America. And the common characteristic of these countries, as you can see, is that they have no access to the sea. Some of them have access to inland seas, or what's known as enclosed, semi-enclosed seas. But nevertheless, they are landlocked countries because they have no access to the main oceans and seas. Now, so the things we are talking about, the living resources of the sea, these include plants at sea, mammals, fisheries, crustacea, malakas, and so on and so on. In other words, the living part of the sea, as opposed to the minerals and other hydrocarbons and that kind of thing. Now, the vast majority of the living resources are actually fisheries, and they account for about 84% of the catchable species of the sea. Mainly they are tuna fish in the high seas. You also get, as you know, some of you might have heard, you get references to sedentary species, migratory species, androgynous species. These are fish like salmon which breed at sea and then go up, and there are those which breed up country and then come at sea. So there are a lot of things we're talking about. But I think the basic ones are the fact that they are living resources, including whales, seals, tortoises, and that kind of thing. Now, there are many provisions, so those of you who have followed the law of the sea convention, there are many provisions in the convention which touch on other aspects of landlocked countries. I'm not going to go into those because we don't have much time. All I can say is that the main part of the convention which deals with landlocked countries is part 5 of the convention. That is Articles 55 to 75. Okay? Now, the most important of those conventions, those articles, are 2 articles. Article 69 in Article 7. April 1, which talk about the rights of landlocked countries over marine living resources. When we talk about living resources on the sea, there are a lot of other issues we can go like IUF, which is unlawful unregulated fishing. Okay? And there are a lot of other fishery issues which are involved in it. I had the opportunity, I had the rare chance of working for the United Nations. And I know that at the United Nations, there are various agencies dealing with specific things. The IMO deals with the safety aspect of shipping, AMTA deals with the economic aspect of shipping. But the UN organization which deals with fisheries is the FAO, the Food and Agriculture Organization of the United Nations, based in Rome. Now, the detailed arrangements for fisheries, treaties, agreements, those are governed by the FAO. We don't have time to get into that. We will need another conference to handle that aspect of things. It's a very wide subject. Okay? We don't, as I said, we don't have much time, but I just want to mention a few things as a way of going forward. The convention, this is the convention here, this convention, divides landlocked states, as my colleagues have indicated, into 1, the general landlocked countries, B, developing landlocked countries, and C, developed landlocked countries. Those are covered in Articles 69 and Article 7. We can't go into the details. Now, there's something curious about what my colleague has just said with the geographically disadvantaged countries. They actually, in the convention, they are not landlocked countries. A lot of them are actually coastal countries, including countries that border enclosed or semi-enclosed seas. My contention is that by the very nature of the definition, developing countries should be geographically disadvantaged. And we've already talked about that, the fact that they don't have access to sea, they are deprived in many ways, but the convention does not regard developing countries, landlocked countries, as geographically disadvantaged. But that's another day. Now, as I say, I have listed about 20 issues you can see, which is, I've listed about 20 as issues relating to the rights of landlocked countries on living resources. I can't go through all that. Okay? What I will do, however, is this. I'll just give you the gist of the way the convention has approached the rights of landlocked states over living resources of the sea. It's been mentioned that during the negotiations of the Law of the Sea Convention from 1973 to 1982, about 10 years, there was a group of 50 countries which fought for these rights. It's like the 99 states, or the group of 77, which you remember, fighting for particular rights. Unfortunately, they didn't get very far. They wrestled some rights from the coastal states. My reading of Article 65 to 75, and especially Article 69 and Article 70, is this. It leaves the paramount rights over living resources in the hands of the coastal state. To an extent that even the rights which these countries have been given are still subject to about 20 different conditions. And I listed those 20. I'll just go through a few of them. For instance, the landlocked country the landlocked state can only participate in the EEZ of a coastal state in the same region or sub-region. You can't cross regions or sub-regions. You see, so that in itself is a restriction. The other limitations, for instance, are such things as the landlocked states are only entitled to participate in the surplus of the harvest of the resources, not in the whole quota, only in the surplus, which those are areas which the coastal state, no, don't worry about it. Those are aspects which the coastal state does not need to exist. So you can see the limitation. If there are no surplus, then that's it. The coastal state, so the landlocked state will have no access. The arrangements are only through agreements and other bilateral arrangements between the coastal state and the landlocked state. And as I say, those arrangements, not the details of these arrangements, are normally done by an organization like AFO. There are a lot of other restrictions. Under Article 71, the coastal state can suspend any rights which they have issued or which they have given to the landlocked state if they're having problems with various issues, like if there's not enough fish. If they have maybe other political reasons could be, but they can suspend that right. The convention also retains the right of the coastal state to give equal and preferential treatment to other countries in the zone. They are not bound by what the convention says. So a landlocked state cannot, for instance, say, why are you giving preferential equal and preferential treatment to this country? No, they can't do that. In other words, the picture I'm painting is that the convention gave with one hand and took away with the other hand. And actually, the consequence of this is that the landlocked states, in my view, have had a very bad deal. It's been mentioned that a lot of them are part of what we call the least developed countries or the poorest countries in the world. A lot of them actually do not participate at all in the law of the sea. Very few of them have actually ratified the convention. So I'm sorry that this is a rather negative but very depressing state of affairs which I'm delivering. But I hope you don't blame me for conveying bad news. Thank you very much for this.
Thank you very much, Mr. Adekun. Now our last speaker, Professor Natif Asafarov. He's from Azerbaijan. He works as a professor to director of Bakü University, State University. Please,
Teşekkür ederim Sayın Başkan, sayın hocalarım, sayın katılımcılar. Ben de kendi görüşüm adına herkese saygı ve sevgiyle selamlıyorum. Benden önce Sayın Hakan Karan Hocam ve diğer konuşmacılar benzer kıyısı olmayan devletlerin durumuyla ilgili bazı konulara değinildi. Ben de bugün benzer kıyısı olmayan devletlerin seyir sefer hakları ile ilgili olan bazı konulara değinmeye çalışacağım. Şimdi bununla ilgili uluslararası düzeyde farklı düzenlemeler yapılmaya, sözleşmeler kabul edilmeye çalışılmış ve bunların bir kısmı doğrudan denize kıyısı olmayan devletlere yönelik olduğu halde bir kısmında genelde onların durumunu etkileyen sözleşmelerdir. Bu düzenlemelerden birisi ve ilk olarak karşımıza çıkan bildirge 1921 yılında Barcelona Konferansı'na kabul edilmiş benzer kıyısı olmayan devletlerin bayrak haklarını tanıyan bir bildirge. Bu bildirge şu an itibariyle 50'den fazla devlet tarafından imzalanmış ve bu bildirgeyi imzalayan, onaylayan devletler kendi bayrağı altında denize kıyısı olmayan devletlerin gemilerini seyredebileceğini kabul etmiştirler. Bugün için bu devletlerden Azerbaycan, Moldova, Moğolistan, Bolivya, İsviçre gibi devletlerin birçoğunun ticari gemi yollarını kullanmaktadır. Ve mesela Azerbaycan veya Moldova'nın bugün denizlerde, okyanuslarda yaklaşık 500'e kadar bayrağı altında yüzen gemiler var. Ve hatta bazı devletlerin, Etiyopya, Moğolistan gibi devletlerin denize ulaşabilen nehir, deniz limanı bile bulunmamaktadır. Ve hatta bazı devletlerin, Azerbaycan, Türkmenistan, Kazakistan gibi devletlerin kendine ait deniz kuvvetleri, deniz donanması bile var. Ve bu düzenlemeler ilk bildirge çerçevesinde denize kıyısı olmayan devletlerin kendi bayrağı altında denize seyredebileceği hakkı tanınmıştır. Diğer bir düzenleme doğrudan denize kıyısı olmayan devletlere yönelik olmasa da onların durumunu etkileyecek bir uluslararası sözleşme 1947 tarihli gümrük tarifeleri ve ticaret genel anlaşmasıdır ki bu anlaşmalar da 5. madde gereğince GATT üyesi devletleri denize kıyısı olmayan devletler de dahil olmak üzere tüm devletlere transit trafik hakkı tanındığı görülmektedir. Ve bu GATT üyesi devletler denize kıyısı olmayan devletlerle transit geçiş trafik hakkının sağlanması için uluslararası düzeyde sözleşme yapma yükümlülüğü getiriyor. Veya diğer bir sözleşme 1965 tarihli New York'ta yapılan konferans sırasında kabul edilen denize kıyısı olmayan devletlerin transit ticaretine ilişkin sözleşmedir ki bu sözleşmede aynen denize kıyısı olmayan devletlere yönelik bir sözleşme olarak onlara bu konvansiyonu, sözleşmeyi onaylayan devletlerin kıyılarından, limanlarını kullanırken onlara da aynı haklar, yani transit geçiş hakkının tanınmasıyla ilgili bir sözleşme vardır. Aynı zamanda bu transit geçiş hakkı 1958 tarihli sözleşmelerde ve 1982. yıl tarihli Birleşmiş Milletler'in Hukuk Sözleşmesi'nde de geçerlidir. Belirttiğimiz sözleşmelerin hepsinde bu tür devletlere transit geçiş hakkı tanınsa bile bu hakkın kullanımı aynı zamanda transit devletlerin iznine onlarla yapılan sözleşmelere bağlı bulunmuştur. Bildiğiniz gibi 1958 yılında Deniz Hukuk Konferansı sırasında kabul edilen Karasular ve Bitişik Bölge Sözleşmesi, Açık Deniz Sözleşmesi doğrudan denize kıyısı olmayan devletlere ise hakları, o cümleden seyir sefer hakları tanınmıştır. Ve daha sonra 3. Deniz Hukuk Konferansı sırasında kabul edilen konvansiyonda bu hakları teyit etmenin yanı sıra yeni bir bölüm olarak 10. bölüm karşımıza çıkmaktadır ve bu bölüm denize kıyısı olmayan devletlerin denize ulaşma ve transit serbestlisi hakkını tanıyan ayrıca bir bölümdür. Şöyle ki 1958 Cenevre Açık Deniz Sözleşmesi'nde ve 1982 tarihli Birleşmiş Milletler Deniz Hukuk Sözleşmesi'nde tüm devletler gibi denize kıyısı olmayan devletlerin de açık deniz serbestlisi hakkı olduğu kabul ediliyor. Yani bu hak çerçevesinde sadece denize kıyısı olan devletler değil, aynı zamanda denize kıyısı olmayan devletlerin açık deniz serbestlisi hakkına dahil olan seyir sefer serbestlisinden yararlanma hakkı vardır. Bu hak sadece açık denizlerde değil, aynı zamanda devletlerin münhasır haklara sahip olduğu münhasır ekonomik bölge, çift bölge ve de geçerli olduğu görülüyor. Aynı zamanda kıta sahalığı devletlerin sadece denizin dibinden ve pekinden kullanım amaçlı olduğu için, su alanlarını etkilemediği için tabii diğer devletlerin de su alanındaki seyir sefer haklarını etkilemez. Yani denize kıyısı olmayan devletler aynı zamanda bu alanda da seyir sefer hakkına, serbestisine sahiptir. Denize kıyısı olmayan devletler sadece açık denizlerde değil, aynı zamanda diğer devletlerin egemenliği altında bulunan deniz alanlarında da, yani iç sular, kara sularında, takmada sularında bile seyir sefer haklarına sahip. Şöyle ki 1958 tarihli Cenevre ve Karasular İlişik Bölge Sözleşmesi'nde ve 1982 tarihli Birleşmiş Milletler Deniz Hukuk Sözleşmesi'nde bildiğiniz gibi iç sular düzenlenmiyor. Sadece düz hat yöntemi kullanılarak eskiden önceden iç sular olarak kabul edilmeyen düz sular, iç sular olarak kabul edersek o zaman tüm devletler gibi denize kıyısı olmayan devletlerin de bu alanda iç sularda zararsız geçiş hakkına sahip olacağı düzenlenmiştir. Aynı zamanda kara sularında da zararsız geçişi düzenleyen hükümler tüm devletlere bu alanda belirli kurallar, şartlar dahilinde zararsız geçiş hakkından kullanabileceğini ve bu hakkın tüm devletlere, hiçbir ayrım yapılmaksızın tüm devletlere ait olduğu, aynı zamanda denize kıyısı olmayan devletlerin de bu şartlar, koşullar altında zararsız geçiş şartlarına uygun seyir sefer hakkını yararlanmak hakkına sahiptir. Aynı zamanda 1982 tarihli sözleşmede de uluslararası seyir sefer için kullanılan boğazlar ve takmada sularında da belirli şartlarla, belirli kurallarla geçiş hakkı tanınıyor. Mesela 82 tarihli sözleşmenin 3. bölümünde uluslararası seyir sefer için kullanılan boğazlar belirli tasdifatı yapıldıktan sonra orada yapılacak, kabul edilen geçiş haklarından tüm devletlerin yararlanabileceği, o cümleden denize kıyısı olmayan devletlerin de yararlanabileceği belirtilir. Takmada sularında aynı zararsız geçiş hakkının olduğunu görüyoruz. Ve bu hak da aynı zamanda denize kıyısı olmayan devletlerle ilgili olarak yararlanabileceği bir haktır. Ve sonunda Hazar Denizi'ne kıyısı olan devletler açısından, o cümleden Azerbaycan açısından konuyu değerlendirmek istiyorum. Bilindiği üzere Hazar Denizi ile ilgili uzun süre tartışmalar, işte Hazar'ın kapalı deniz mi, sınır gölü mü veya kendinden has özellikleri olan su havzası olduğu ile ilgili uzun süre tartışmalar var ve hala sürdürülüyor. Fakat 2018 yılında Hazar Denizi'nin hukuk statüsü ile ilgili bir konvansiyon imzalandı. Henüz yürürlüğe girmese bile bu konvansiyon çerçevesinde Hazar'ın sadece 5 kıyı devletine ait bir su havzası olduğu kabul edilmiş ve en azından uluslararası düzeyde hukuki statüs olarak Hazar'a deniz değil su havzası olduğu kabul edildiği için Hazar kıyısında yerleşen devletlerin Azerbaycan, Türkmenistan ve Kazakistan'ın denize kıyısı olmayan devlet olarak kabul edileceği ve diğer devletlere tanınan haklardan Azerbaycan'ın ve diğer devletlerden yararlanabileceği kanaatindeyiz. Bilindiği üzere 2024 yılında Birleşmiş Milletler çerçevesinde denize kıyısı olmayan gelişmekte olan devletlerin ilişkin konferans düzenlemek planlanıyor. Biz de tabii ki demin söylendiği gibi ülkelerin gelişimi ve uluslararası ticari faaliyette denizlerin önemini kabul ederek denize kıyısı olmayan devletlerin bu dezavantajlı durumlarını ortadan kaldırabilmek için daha fazla uluslararası işbirliği yapılması gerektiğini düşünüyoruz. Dinlediğiniz için teşekkür ederim.
We will open the question period. Thank you very much for your very important topic, all panelists. If you have questions, please your name and from your institution maybe.
Thank you.
Do you have a microphone?
Yes. Yeah. From England, I'm a member of the International University as well. Thank you very much for this interesting speeches. My question to the professor, first speaker. He mentioned the access to the sea and the ocean. I would like to understand if there is any difference between the access to the sea and the ocean, because I don't understand. Some countries, they have an access to the sea, but if they want to be a superpower, they will need an access to the ocean, because without having an access to the ocean, you wouldn't have like submarines. Are we differentiated now for an essential access to the sea, or or there is a difference between having access to the sea and ocean? Thank you.
Thank you for the question. Actually, we use the concept of ocean to cover all the seas, technically. When we say ocean, it covers all the seas which are connected to each other. So there is no unconnection between them. As Hakan Karan said, all the states are neighboring states as far as oceans or seas are concerned. When we talk about landlocked states or geographically disadvantaged states, we are not really talking about the navigational rights, because it's open to all countries. You know, all countries may have ships, even if it's a landlocked country. That country may have ships in the oceans, in the seas, and can use, according to the 1982 of the Convention, the coastal states should provide ports freely to these countries' ships. But we are talking about here the benefits that come from the natural resources, not navigation rights. Navigation rights are open to all states, whether landlocked or coastal states. We are talking about especially the natural resources of the high seas, exclusive economic zones, and the seabed under the high seas. So that's why all the rights in the 1982 laws of the Sea Convention are actually talking about the rights to the natural resources, and also the right to transit through the transit countries that are located between the seas and the landlocked states. So, when we say oceans, it covers all the sea areas, and when we talk about the landlocked and geographically disadvantaged states, we are actually talking about the rights to natural resources rather than navigation.
Thank you very much. Eğer Türkçe soru sormak istiyorsanız, Türkçe sorularınızı yöneltebilirsiniz. So, please. Can you give me? Which one will you prefer?
Okay, thank you very much indeed. First of all, my name is Bayram Mustafa. I'm from Istanbul University, Shares Faculty, and head of the Turkish Research Foundation. And I'm so appreciated that Mr. Karan invited me, and I'm very thankful to the organizing committee. My question is to Professor Odey. Professor, he said landlocked countries has a right. At the same time, Professor Odey also said this. I can understand this. It's right, legally, but there is no resource anymore in the oceans. If they come to the Atlantic Ocean, what they will call? What they will catch? Plus, this afternoon there is an MPA's speech, Marine Protected Areas. So almost 20% of the world ocean should be MPA's within 2 years, next 2 years. So there is no fish anymore, there is no crustaceans anymore.
There is no surplus.
Sorry?
There is no surplus, as you say.
I'm coming to this point. So surplus productions, Austria is a member of the European Union, and they are in Mauritania, Turkey as well. We do same thing. We catch their surplus production in Mauritania. They are a member, they are a landlocked country, but they are also in the Mauritania, or competitor as well. Anyway, so I think we have to think about the sustainability and because most of the resources are depleted. 20 years ago, the resource was 130 million tons on oceans, now almost half. Thank you very much.
Thank you very much. I agree with you entirely, and I have nothing to add. Thank you.
I can add a couple of points if you allow me. In 1982 law of the Convention, there are provisions which are saying that landlocked states or geographically disadvantaged states may have an access to natural resources without damaging the environment, without damaging the living resources of the oceans. There are some preconditions and some measures provided by the Convention. As Professor Bayram says, the sources of the seas are declining, so I think there is no area to cooperate between coastal and landlocked states. That's quite a very significant observation.
Okay, thank you very much. Do you want to start? No, okay. After that, maybe before.
Hello, thank you so much.
It will be not question. Please keep your microphone and please ask something.
No microphone?
You can turn yes.
Yes, it's a kind of question, same coin, but the problem is that thinking about Africa, Mauritania, whatsoever, I mean all these countries, in the Law of the Sea Convention, there is an order. The fishery resources needs to be distributed, starting from the landlocked states, especially if they are developing ones, and then to developed states. But the practice is just opposite right now. In Africa, especially European Union countries, they are there and they got an agreement with these resources. So what about the access of the all non-developing or developing states, including ones landlocked states, to share or get enough share from the seas? If there is not enough capacity right now, what would be the position of the European Union or other developed states, Japan, European Union, China? So they are not only access to the seas physically, but also legally as well. So this is my point.
Thank you very much.
Thank you for your presentation. I have just the question which continues the logic given by Professor Karan. We talk the various starting points given by ANCORS, and we said that the resources should be shared. And we know that there are different types of countries, and we underline what kind of countries we have in ANCORS, right? And we also said that there are resources that should be shared, but my question is rather than procedural one, how we can deal with the sharing of resources between developed countries, landlocked countries, and geographically disadvantaged countries. How we can collect them together and give them this frame, this opportunity, this fora to sit together and to start to share their knowledge, but not only the knowledge, but also skills, infrastructure, technology, and all related resources and information. Thank you for the question.
Thank you very much.
Opportunity for the question.
Yeah, that's a very good point, not only for the maritime areas as a whole. You know, Millennium Development Goals are very significant. I think United Nations has not been successful at all in fighting against poverty so far. We mostly talk about the failure of United Nations against protecting the peace, but also we should talk about another very significant reality in the world, that poverty is still a very significant issue in the world. And it also causes, many regional wars to start. That's why this Millennium Goal achievements aims are very important. It's also important for maritime cooperation between developed countries and underdeveloped countries or developing countries. As Professor Karan said, the situation in the field is quite vice versa against the provisions of 1982 Law of the Sea Convention. Strong countries in fisheries are actually fishing the limited resources of the poor countries around the oceans. And the convention is there to change the situation, but the poor countries are in the mercy of developed countries, unfortunately. So they make these kind of regulations. The European Union and Japan, I think, are to blame in the first. So European Union countries are, not doing this very well. Concerning these Millennium Development Goals, and I think we should keep emphasizing this fact that European Union is to blame for many countries concerning the fisheries rights.
But just to add something to the very last point, it's not only Japan and the European Union, there are others. It's China, for instance, is also doing quite a lot of fishing in various parts of the world. But I want to take the floor for another reason. Because I think at the United Nations Conference on the Baltic Sea, a lot of time, perhaps too much time, was spent on the seabed and on mineral resources, and too little time on fisheries. But the reason is that to achieve compromise on fisheries was so extremely difficult, and the creation of an international organization to deal with worldwide fisheries would have been a non-starter. So we concentrated on the deep seabed and the minerals, and I was one of the negotiators at the convention, and I remember in 1974, just after the conference had started, I read an article in the New York Times which said, the benefits to be derived from deep-seated mining are either fantastic, marginal, or non-existent. It depends on whom you talk to. And this, to a certain measure, is still true today, because the trillions of dollars on the deep seabed, this was a vastly over-optimistic prediction. And now, as deep-seated mining is about to begin, perhaps within the next few years, we should not expect any major riches to be derived therefrom, because environmental concerns are much more important than 30 years ago. And the regulations to be adopted by the civil authority for exploitation of mineral resources will be very strict. This means the net proceeds will be much smaller. So that's why there is discussion going on to depart from the original idea to distribute money to all countries of the world to be derived from deep-seated mining, perhaps set up a seabed sustainability fund to be used for marine scientific research and for the protection of the environment.
Okay, thank you very much. Thank you, Dale.
Hürmetli dostlar, hürmetli dolarlar, benim sualım Dr. Natik Askerova'dı. Dear ladies and gentlemen, dear participants, my question, let me first introduce myself. My name is Farid Aliyev. I'm a chairman of Kazakhstan Bar Association and professor of UMIP University from Almaty. So the question is, you've mentioned that during the years of negotiation of the legal status of Caspian Sea, it was an experience of the resolution of dispute resolution between at least 5 countries. So my question is, Caspian Sea status is something specific, or is it possible to apply this experience for other similar cases? Thank you.
Teşekkür ederim. Demin de söylediğim gibi Hazar Denizi ile ilgili zaten tarihen uzun süre tartışmalar devam etmiştir ve halen de sürüyor tartışmalar. Ve zaman zaman belirli uluslararası açıda bilen sözleşmeler yapıldı. Ama hiçbirisinden Hazar'ın hukuki statüsüyle ilgili bir belirgin bir sonuç elde edilmedi. Sadece 2018 yılında Hazar Denizi'nin hukuki statüsüyle ilgili sözleşme imzalandı. 5 kıyı devlet tarafından imzalanmasına, onaylanmasına rağmen İran tarafından ratifikasyon yapılmadığı için hala yürürlüğe giremedi. Fakat o konvansiyona baktığımız zaman konvansiyonda 5 kıyı devleti Hazar Denizi'nin sadece 5 kıyı devletini su havzası olarak görüyor. Yani ne deniz değil, ne göl değil. Ve bu açıdan baktığımızda artık Hazar Denizi'nin kullanımında sözleşmede farklı mesela kara suları, iç suları, münhasır ekonomik bölge değil, balıkçılık bölgesi olarak görülüyordu ve akvatoryalı sektör olarak görünüyor. Bu açıdan Hazar'ın deniz olmadığı, en azından 5 kıyı devleti açısından uluslararası düzeyde bu hukuki sonuç elde edildiği için bu konvansiyon açısından Hazar'ın deniz olmadığını ve bu 5 kıyı devletin denizde, daha doğrusu Rusya ve İran'ın diğer denizlere ulaşımı kıyısı olduğu için 3 devlet, Türkmenistan, Kazakistan ve Azerbaycan'ın denize kıyısı olmayan devlet olarak nitelendirilebileceğini düşünüyorum.
Okay, thank you very much.
Mr. Chairman, I know I had foregone my right to answer questions from the gentleman from Istanbul. But it appears that I think the drift, the interest in the conference is towards fisheries, towards the unfairness that's taking place in the fisheries. I've had the rare opportunity of advising many countries, and I have witnessed what the gentleman was talking about. For instance, in the Seychelles, there were vessels from South Korea. They had an agreement with the government of the Seychelles to fish. It was a very basic agreement, whereby they would come, they would, come, bring the vessels, net tonnage, the vessels away, then they go out, and then they come back, and then they weigh how much fish they have caught. What turned out was that they did not actually declare how many vessels were there. And in the end, only declared half of the vessels which they had. The other vessels stayed very far out in the open seas. And they probably took 90 or 100%. Well, what they declared was maybe about 10% or 20% of the fisheries. I mean, there are a lot of other issues that take place, like, the unlawful, the undeclared, using drag nets. You get these ships drag a net 2 kilometers long, 3 kilometers long, and they scoop everything, including sharks, turtles, it's just mayhem. There is no rule out there. I also had the opportunity to go to Mauritania and Tanzania. And out there, I mean, normally I don't like to mention countries, but I think a lot of this is open secret. The Russians, for instance, they have what's called fish factories. These are huge fish factories where you get about 100, 200 people working in the fish factory. These vessels come out, the mothership comes out and brings smaller trawlers with them. Okay? The trawlers then catch the fish, take the mothership, the fish is processed, and even tinned and packaged within the vessel. And they have the audacity to sell this fish to the countries with which they had the agreement. It's just the sort of thing that is happening. We're going to have a session on the blue economy, I don't know, but I think fisheries is probably, to me, is top of the list in what is happening. As the gentleman said, we might not have any fish in a few years' time because we are scooping everything, including young fish. We are supposed to throw them back, according to the agreement. We don't. And then when you catch young fish, and there is no more young fish left, so you can't get any more fish, producing more fish. But that's what we are having. I know that the rights of developing countries was only the tip of the iceberg. But we have fundamental problems. We have real fundamental issues. This document here, as my colleague, the professor, said, this document was a compromise in many respects. Okay? It was just a compromise. And I think one of the biggest compromises, as the professor said, was the compromise over fisheries. They just didn't think that they could pursue that as well as dealing with the deep sea mining. Now, this being a compromise and being a code, we need other conventions to supplement this convention. For instance, in the underwater cultural heritage, we now have a UNESCO convention which deals with underwater cultural heritage, which there are only, I think, 1 or 2 articles here on underwater cultural heritage. I think we need a supplementary convention to deal with the fisheries, because it's one of the major resources that we have access to, especially developing countries. Okay? But otherwise, I agree with what you're saying. Maybe we should have another conference just focus on the unfairness of fishing and fisheries. Thank you very much.
Thank you very much. There's no question anymore. Last question, yes.
Thank you very much. My name is Leo Bernard. I'm from the Australian National Center for Ocean Resources and Security. I have a question for Judge Turk. Because I'm very interested about the role of landlocked countries in the ISA. And as you mentioned, it seems like we won't see any benefit from deep seabed mining anytime soon. But most of the landlocked countries are the least developed countries in the world. And I imagine maintaining representation in Jamaica wouldn't be cheap. And it seems like this financial, or the limitation for financial resources has become a barrier for these landlocked countries to participate more fully in the ISA. My question is, has there any efforts, either from the UN or from the ISA or from the group of landlocked countries themselves, to address this lack of participation? Because I feel like it's unfortunate, because one of the reasons the regime of the area was created are for the landlocked countries, to ensure they have can participate in the common heritage of mankind. And the fact that they haven't fully participated, it's unfortunate. So I'm just wondering whether there's any effort to address that concern. Thank you.
Well, thank you. That's a very, very pertinent question. Let me say the following. First of all, there has to be a generational change in many countries. Those representatives from developing landlocked countries which participated in the negotiations are mostly gone. And a new generation has only arisen to a very limited extent, because when it became obvious that deep-seated mining would be a long way off, at the conference we believed that deep-seated mining would begin in about 20 years. Now 40 years have passed, nothing has started. That's why many developing landlocked countries lost interest in the whole matter in the civil authority. Secondly, it is a challenge to send delegates to Jamaica that is extremely expensive. And I've had myself problems with the Austrian Foreign Ministry in the past for financial reasons. So efforts are made to support developing countries to participate in the meetings, but the interest of the landlocked country has been very limited. Therefore, the International Civil Authority is doing everything it can to persuade those countries, and just recently a brochure was published which is called "Those Landlocked Developing Countries, an Ocean of Opportunity." And at the forthcoming conference on developing landlocked countries, this brochure will be distributed and propagated in order to persuade those countries to consider the benefits they may derive from the deep seabed. Of course, this will be a few years off till we receive benefits, but once we do get benefits, besides the Seabed Sustainability Fund, I'm certain that a certain amount of these monies will also be transferred to developing landlocked countries And what is also important, young people, men and women from developing landlocked countries are being trained. They're included in programs, from programs devised by the International Civil Authority. I think I've even written down some in my paper. Yeah. Since 2017, a series of activities have been undertaken to reinforce the actions of the civil authority in building the capacities of its members. Amongst landlocked developing countries, 12 individuals from 10 states, Armenia, Bolivia, Botswana, Burkina Faso, Chad, Eswatini, Malawi, Mali, Niger, and Zambia, have benefited from ISA training programs.
Okay, thank you very much. Now, there's no question anymore. Okay, I would like to thank you, each one of you, for joining this your Asian meeting program. Now we are at the end of our